Now that we've covered the statement of claims, next is the statement of defense and your defenses against the negligence claims. Remember how we discussed in the previous video that the statement of claim lists all the ways that you're a terrible doctor and how you need to write a very large check to make up for your terribleness? Well, the statement of defense is basically your reply to that, which in fact you say you are the world's best doctor, wonderful in every aspect, and in fact you should be probably nominated for a Nobel Prize. The statement of defense is a legal document written by your lawyer based on the information that you provide. Like the statement of claim, there are several elements that need to be included, and the most important source of information is what you provide in the narrative summary. This summary is strictly between you and your lawyer and is called privileged. This means that everything that you write will always stay between you and your lawyer. The narrative summary is your summary of the case based on your recollection and information from the chart. You describe your involvement, and it is critical that you be as honest and open as possible with your lawyer. Feel free to relate any other thoughts you have surrounding the case that may not necessarily be in the medical record. Now, in order to write the narrative summary, you need to have the patient's chart. And as I said before, you should be very careful about looking at the patient's chart without advice from your lawyer. There are privacy laws that you could potentially run afoul of accidentally, and so really you should only access the chart after you have spoken to your lawyer. Furthermore, if you have any notes from your clinic, you need to give a copy of them to your lawyer. This is actually very vital because fairness in law means that both sides must have access to the same information to make their best decision about the case. And in fact, if you don't turn over this information to your lawyer, you may automatically lose the case. But it's important to remember that you should only give that information to your lawyer only, never directly to the other side. You should write your narrative summary so a layperson can understand it. Your lawyer is not a physician and needs to use the narrative summary in order to write your statement of defense. So it's important that you use layman terms to explain any important details and to help them understand what happened. Now, when writing your narrative summary, start with a brief introduction of yourself, including your role at the time and how long you cared for the patient. You should also list all of the sources of your information, such as the hospital record, any clinic notes that you have, personal notes, and your memory. Then provide some context to the case in 1 or 2 sentences by briefly summarizing the case up until your involvement. Then next, detail your involvement in the case chronologically. Explain any concepts that may be important for non-medical readers to understand. So, for example, the phrase secondary injury from cerebral edema could be better explained as when the brain is injured, it swells just like any other tissue in the body. Because the brain is in a fixed compartment, the skull, the pressure on the uninjured part of the brain from this swelling can cause previously uninjured parts of the brain to become damaged as well. Stick to the facts of the case as can be demonstrated from the chart. You don't need to list lab values or be overly detailed with the data, but your summary should focus on explaining what happened and why you did what you did. Finally, you can conclude with some personal thoughts on the case where the information will help your lawyer better understand the context and any other issues that might be important for your lawyer to know, such as, wow, it was really busy that night and I think we were really overwhelmed, or wow, Dr. Y really screwed up in my opinion. Don't worry, no one else will ever see that note. One thing I've noticed over the years is that my memory is terrible, and when I get a statement of claim, I have no recollection of the patient whatsoever. I take care of hundreds of patients a year, and there's no way to keep track of everyone. The other problem is that memories can be easily contaminated from a variety of other sources of information. For example, even today, I have a very firm memory of an event that happened in the first lawsuit that I was ever involved in. But according to the chart, the event occurred before I ever actually saw the patient. Now, I know that this false memory formed when I read a very vivid description of it in the chart, and then it was then subsequently reinforced by talking to people who were at that event at the time. The problem is I can't get rid of that false memory, even though I know it's false, because every time I think about it, just happens to strengthen that memory trace. And unfortunately, that's just how memory works. So now, when I get a statement of claim, if I happen to remember anything about that patient, I write it down immediately before I talk to anyone or I read the chart. Otherwise, I rely strictly on the medical record to write my narrative summary. Now, in the last video, we went over all the necessary elements of a negligent lawsuit in order for it to succeed. And you may feel like there's no hope for you, but in fact, you really have some very strong defenses against the claim at your disposal. These include, number one, the physician followed the appropriate medical practices. Number two, at most, the doctor was only committing an excusable error of judgment. And number three, the patient was wholly or partially the author of his own misfortunes. And then finally, four, the time limit to initiate the lawsuit has expired. We're only going to focus on the first three because the fourth is really just about time limits, which is something your lawyer will almost immediately pick up on, and no competent patient lawyer will even bother suing you if they know that the time limit has expired. Your first and probably strongest defense is that you were following approved practices used by other comparable physicians at the time. This defense is specifically focused on the claim that you breached the standard of care. The key phrase here is at the time, because you're held to the standard of care as it was at the time of the event. So if, for example, you used frozen frogs to treat duodenal ulcers in 1964, the patient can't sue you today for failing to use H. pylori eradication therapy because that wasn't known at the time, and shockingly, frozen frogs was considered a reasonable treatment for duodenal ulcers at the time. The burden of proof is on you to show that you followed the standard of care at the time and that others would have done the same thing in your shoes. This means you need to rely on good notes in the chart that explain why you did what you did, expert witnesses, and the medical literature to demonstrate that others would have done the same thing. Now, there's often practice variation, and in that you still have a defense if you can demonstrate that a reasonable minority of physicians would have done the same thing under those circumstances, recognizing that there were alternative treatments or methods in use at the time. As well, deviating from accepted practice is not necessarily problematic as long as, again, you can justify why you did it and others would feel that this deviation was reasonable under the circumstances. The next defense is that you didn't commit negligence but simply made an error in judgment or a mistake. Fortunately, we live in a country where physicians are permitted to be human beings and human beings can make mistakes. It is well established that an error in judgment, such as an incorrect diagnosis, does not necessarily constitute negligence. The law does not expect us to be perfect, nor are we judged by the patient's outcomes. However, an error in judgment is not a shield. You can't misdiagnose septic shock as a stubbed toe and expect to be protected against a negligence claim, because no reasonable physician would make that mistake. You can use an error in judgment defense when you can show that a reasonably careful, skilled, and knowledgeable physician in your situation may come to the same decision, and you employed reasonable care, skill, and knowledge in coming to that decision. However, there is no defense if you fail to reconsider your diagnosis when it was appropriate. The initial incorrect diagnosis could be a defensible error in judgment, but the failure to reconsider could be considered negligent. The final defense you can raise is the patient's contribution to their own injuries. Just as a physician is held to a reasonable physician standard, the patient is held to a reasonable patient standard. If a patient doesn't act to prevent further injury, and you can show that their inaction contributed to making it worse, then any compensation that they can claim will be reduced by the degree of their own negligence. So, for example, Say a patient leaves the hospital against medical advice with a central line and then returns with septic shock from endocarditis because they've been injecting drugs despite being warned not to do so. This patient cannot expect to hold you responsible for his own actions. Today we covered the next steps that you need to take after being served with a statement of claim, how to write your narrative summary, and the defenses against a negligence claim. There are three main defenses against a negligence claim. Number one, you followed approved practices. Number two, you only committed an error in judgment or simple mistake. And number three, the patient is partially responsible in some way for their own misfortune. Next time, we're going to dig a little bit deeper into the role of the expert witness and the importance of good documentation in the medical record. Until next time.